team at Gradeup. A very warm welcome to all of you and a very good afternoon to all of you. My name is Surajit and today we are going to discuss, rather talk about the appointment of judges to the higher judiciary. Today, friends, we are going to discuss about appointment of judges to the higher judiciary. Today we see how judges in the High Court and the Supreme Court are appointed. The topic of our discussion today is how are judges to the High Court and the Supreme Court appointed? What are the constitutional provisions relating to the appointment of judges to the higher judiciary? These are those things that we are going to discuss today. We will also further look into the various judgments of the Supreme Court and the birth of the Collegium system, which is the mode of appointment of judges to the higher judiciary. So if a question comes in your law entrance examination, CLAT, AILET, or any other law entrance examination, that how are judges to the High Court and the Supreme Court appointed? The correct answer would be the Collegium system. So before we understand this Collegium system, it is important for us to know some basic facts about the appointment of judges. Let's first see what does the Constitution of India talks about insofar as appointment of judges to the High Court and the Supreme Court is concerned. Article 224 of the Constitution of India states that every judge of the Supreme Court shall be appointed by the President after consultation with the Chief Justice of India. So every judge of the Supreme Court is appointed by the President of India after a consultation with the Chief Justice of India. Similarly, Article 217 of the Constitution of India says that every judge of the High Court will be appointed by the President after consultation with the Chief Justice of India. So there are two important constitutional provisions, Article 124 and Article 217. These two articles talks about the appointment of judges to the Supreme Court and appointment of judges to the High Court respectively. So both the judges of the High Court and the Supreme Court are appointed by the President of India after a consultation with the Chief Justice of India. So how are judges appointed? Let's see. So judges are appointed by the President as per Article 124 insofar as Supreme Court is concerned. And no, what is the entire process? Let's understand that. So the Union Law Ministry consults with the Chief Justice. The Union Law Ministry consults with the Chief Justice and appointments are made to the High Court and the Supreme Court. Article 124 and Article 217 talks about appointment of judges to the Supreme Court and the High Court after consultation is made with the Chief Justice of India, and the final appointment is being done by the President of India. So initially, judges are appointed by the president. The Union Law Minister used to consult with the Chief Justice. The Chief Justice used to recommend certain names to the Union Law Ministry, and the Ministry used to sanction those names and thereafter present those names to the President of India, and accordingly, the President of India used to appoint those individuals as judges of the High Court and the Supreme Court. Now, in 1993, this is where some changes happens in the appointment of judges. Because during Indira Gandhi's rule, during Indira Gandhi's emergency, certain judges were booted out. They were superseded. Justice Khanna was superseded, as well as other judges of the Supreme Court were also superseded. Now, what do you mean by supersession? Generally, as per the custom of the Supreme Court, the senior-most judge of the Supreme Court is made the Chief Justice of India. As per the convention of the Supreme Court, the senior-most judge of the Supreme Court becomes the Chief Justice of India. But we had seen after Keshwananda Bharati's judgment, Justice A.N. Roy superseded 3 judges. Madam Indira Gandhi superseded 3 judges and made Justice A.N. Ray the Chief Justice of India, and as a result, those 3 judges resigned. So in the second judge's case, the Supreme Court held that the Chief Justice of India has the primacy in judicial appointments. The Chief Justice of India has the primacy in judicial appointments. It simply means that insofar as appointments to the higher judiciary is concerned, whatever the Chief Justice of India says is the final word. Secondly, the Supreme Court in the second judge's case interpreted the word consultation as concurrence. Now, if you read Article 124 or 217 of the Constitution, it says that the President shall appoint the judges in consultation with the Chief Justice of India. Now, there is a huge difference in the term consultation and concurrence. The word consultation means to consult someone. The word concurrence means that person's approval is required. So, erstwhile, the original constitution said that during appointment of judges, the president will consult with the Chief Justice. Now, in the second judge's case, the Supreme Court said that no, you cannot consult with us. Whatever we say, you have to follow. And thus, it established the Collegium system for the appointment of judges to the High Court and the Supreme Court. So, in the second judge's case, a 9-judge bench of the Supreme Court held that the word consultation given under Article 124 and 217 of the Indian Constitution means concurrence and not consultation. Am I clear? Now, it also said that if there is a conflict between the opinion expressed by the President and the Chief Justice, the opinion of the Chief Justice would have primacy. That means whatever the Chief Justice of India says is final insofar as appointments to the higher judiciary is concerned. A very, very important thing for all of you friends. A very, very important and significant thing to know. That the second judge's case in 1993 came up with the Collegium system. Now, what is this collegium system? A collegium is a group of judges who determines who will be the next judge of the High Court or the Supreme Court. So the collegium is a group of judges who decides on future appointments to the High Court and the Supreme Court. Now, as per the second judge's case, the collegium comprised of the Chief Justice of India and two senior-most judges of the Supreme Court insofar as appointment to the Supreme Court is concerned. And the collegium, insofar as the High Court judges' appointments is concerned, consisted of the Chief Justice of India and two senior-most judges of the High Court. Am I clear? So the collegium system comprised of insofar as the Supreme Court judges is concerned, it comprised of Chief Justice plus two senior-most judges of the Supreme Court. Insofar as the collegium of the High Court is concerned, it comprised of the Chief Justice of India and two senior-most judges of the High Court. Now let's come to the third judge's case. In the third judge's case, the Supreme Court expanded the collegium system and held that the collegium, insofar as appointment of the Supreme Court judges are concerned, should comprise of Chief Justice plus four senior-most judges of the Supreme Court, that is 5. And the collegium, insofar as the High Court judges are concerned, should be Chief Justice and two senior-most judges of the Supreme Court, that is 3. Am I clear? Did you understand? Am I clear? Am I clear to all of you? So in the third judge's case, the Supreme Court upheld that insofar as judicial appointments are concerned, the judiciary's say is the final. The final word that comes from the judiciary is final. Whatever the Chief Justice or the collegium says insofar as appointment and transfer of judges is concerned, whatever the Supreme Court say is final, and it is not just a consultatory process, but it is a directory process. Am I clear? Fantastic, fantastic, fantastic. Now, thereafter, in 2014, the government of India, the Parliament, came up with a National Judicial Appointments Commission Act. In the year 2014, the government of India, rather the Parliament, came out with a National Judicial Appointments Commission Act. And it also amended the Constitution by the 99th Amendment Act of 2014. Now, let's see what is the National Judicial Appointments Commission. The National Judicial Appointments Commission proposes a system for appointment of judges to the High Court and the Supreme Court. And this National Judicial Appointments Commission replaces the collegium system. Now, what is NJAC? NJAC will comprise of the Chief Justice of India, two senior-most judges of the Supreme Court, 1, and 2 judges of the Supreme Court. That is, the total number of judges is 3. The Law Minister of India and 2 eminent persons selected by a committee comprising of Chief Justice, Prime Minister and Leader of the Opposition. That is another 2 persons. So there will be 3 judges and 3 non-judges. 6 people will appoint the judges to the High Court and the Supreme Court. Very, very important. So the NJAC, the National Judicial Appointments Commission, is a system for appointment of judges to the High Court and the Supreme Court. The NJAC replaces the collegium system. And the composition of the NJAC is the Chief Justice of India, two senior-most judges of the Supreme Court, the law minister, and two eminent persons who are selected by a committee comprising of the Chief Justice, the Prime Minister, and the leader of the opposition. Am I clear? So there are three judges in the commission and three non-judges in the commission. Am I clear? This act, the National Judicial Appointments Commission Act of 2014, was challenged before the Supreme Court. And the Supreme Court, by a 4:1 majority, held that this NJAC is violative of the basic structure of India. The basic structure doctrine that was enumerated by the Supreme Court in the Keshwananda Bharati's judgment. The Supreme Court held that this NJAC is violative of the basic structure doctrine since it takes away the primacy of the judiciary insofar as appointments to the higher judiciary is concerned. And hence, the system of judges, the system of appointment of judges as existed prior to this NJAC Act, that is the Collegium system, was declared to be operative. So as on today, how are judges appointed? Judges to the High Court and the Supreme Court are appointed by a system that is called the Collegium system. Now, this Collegium system has a lot of criticism. This Collegium system has a lot of criticism. Now, what are those criticisms? NJAC stands for National Judicial Appointments Commission Act of 2014. Okay. Now, what are the criticisms about this Collegium system? The Constitution of India does not talk about the Collegium system. It is a mechanism that has been put by the Supreme Court itself. The original Constitution said that the judges of the Supreme Court and the High Court shall be appointed by the President after consultation with the Chief Justice of India. The original Constitution or the Constitution today does not talk about the Collegium system. It is a system or a mechanism that has been put in place by the Supreme Court itself. Number one, that's the first criticism. The second criticism is India happens to be the only country where judges appoint judges. Nowhere in the world can you see that judges are also appointing judges. For example, in the US, one of the best judiciary in the world, the US Supreme Court. US Supreme Court judges are appointed by the Senate, that is the Parliament, by a committee, the Judicial Appointments Committee. Am I clear? India happens to be the only country where judges appoint judges. And this leads to nepotism, the fear of nepotism. Now, you see in a lot of media and other places wherein you see that, judges appoint the judges, their father were judges, their grandfather were judges, and they have also become judges. There are only a couple of families in India, a handful of families in India from where all judges to the High Court and the Supreme Court has come from. Very sad to hear that. Now, what is so important about those families? Because this system is not transparent. Whatever happens inside the Collegium system is not revealed to the outer world. The court covers itself under an iron curtain. There is a lack of transparency and a fear of nepotism insofar as this Collegium system is concerned. And finally, there is no checks and balances. There is no role of the executive, no role of the legislature insofar as appointments to the High Court and the Supreme Court is concerned. Very, very important. Now, if the Parliament does something wrong, it is subjected to the Supreme Court's judicial review. If the executive does something wrong, it can be challenged before the Supreme Court. If a policy is made by the executive, that is subjected to legislative debates in the Parliament. But now, insofar as the appointment of the High Court or a Supreme Court judge is concerned, whatever the Supreme Court does is final, and the executive or the legislature does not have any role to play. There is no checks and balances. The Constitution talks about separation of the three pillars: the legislature, the executive, and the judiciary. And the legislature, the executive, and the judiciary has been so made that everyone, there is a check and balance over the other. But in case of appointment to the higher judiciary, there is no checks and balances. The role of the executive, the role of the legislature has been taken away insofar as appointment of the High Court and the Supreme Court judges is concerned. And that is why there is a lot of people talking about that there should be an all India judicial service examination. Because to become a judge of a High Court or a Supreme Court, you don't have to pass a particular examination. To get into a law school, you need to crack an examination: CLAT, AILET, SLAT, MHCT, and others. But to become a judge of the Supreme Court or to become a judge of a High Court, you don't have to clear any examination. This system does not have transparency, and there is nepotism or a fear of nepotism in this system. Am I clear to all of you? Okay. Now, in case you guys have any doubts, you can ask me. In case you guys have any doubts, you can ask me right now. Today we did discuss about appointment of judges to the higher judiciary. Appointment of judges to the higher judiciary. How are judges in the higher judiciary, that is the High Court and the Supreme Court, appointed? Am I clear? Okay. These are very, very important classes. Please do attend these classes very, very carefully. Okay. Do like the section if you have liked this video. Do like the section. Yes. Okay. Anurag Verma, how can you take? You can take screenshots of the slides, and thereafter you can read them. Okay. 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 So do like the section. Do subscribe to our YouTube channel, and definitely share this video with your friends who are also preparing for CLAT and other law entrance examination. Thank you very, very much. God bless you. Stay well, stay healthy, and stay at home. Thank you. I'm signing out from Gradeup now. Thank you. God bless you, friends.